Morning and welcome to Employment Hour in 30. I'm John Scholes. This is Lior Samfiru, where we talk about your employment rights, your severance, your boss, or maybe if you are the boss, everything about your employment and your job. We cover each weekend morning here. So thanks for joining us. Anytime you want to get a hold of Lior, 1-855-821-5900. And it is also help@employmentlawyer.ca. That's the email address. So we always start with the week that was, Lior, something that's happening, a matter that came across your desk at the firm. And please enlighten us, shall you?
Well, you know, I've had the privilege over the past few days to speak with a lot of people that have watched our show in the past, and it triggered something, a question, an issue, a concern, and they reached out to me and they wanted to talk about those issues. That's great. That's so important. I'm so happy that people are watching, are responding. So if you're watching us right now, you have a question about your workplace rights, your work situation, maybe you had a bad week or you're not sure what to do if your boss said something or maybe is putting an ultimatum, give me a call. Let's talk about it. Let's find out how you can respond, what the law says, what your options are. This is the time, this is the place. We talk about those things every week. And, you know, if I don't address your specific situation on the show, just call me. Let's talk about your specific situation. Happy to chat. There's no bad questions, no such thing. And always my privilege, my pleasure to talk to anyone. Now, to the week that was, where I talk about a situation that came across my desk over the past few days. This one had to do with workplace harassment. Now, you don't need to be watching the news every day to know that this is a hot topic now. A lot of employees and employers are mindful of the fact that workplace harassment is unacceptable, and it isn't acceptable. In this particular situation, I got a call from a gentleman who was being mistreated by a coworker. Now, this coworker was kind of the star of the company. He was, you know, the highest earning salesperson. He was, you know, well liked by management, and he felt because of that he gets special privileges, including mistreating others. So this particular person was being mistreated. He was talked down to, you know, even through email, even off work. There were some online exchanges, completely inappropriate treatment, inappropriate language, putting him down, and he did the right thing. He complained to management. He complained to HR and said, this coworker of mine, the star of the company, is mistreating me. He's creating this poison work environment. Please do something about it. Well, unfortunately, the company did not do anything. They did a very cursory investigation. It was a bit of a sham investigation. And I guess because this person was the star and they didn't want to upset him, they said, no, nothing happened. It's kind of just boys will be boys, and we're not going to do anything about it. And this person called me and he said, well, what do I do now? I still have to go to work. Things have gotten worse now because I complained. And what are my options? Well, let's make it very clear. A company has strict duties to protect employees from workplace harassment. It's unacceptable. That means they have to conduct a proper investigation, find out exactly what happened, and then take remedial measures. That may mean punishing the person, that the guilty person, even letting them go, providing training in terms of acceptable conduct in the workplace, essentially creating a work environment that's conducive to work. So in this situation, the company failed to do that. They would not do it. They wouldn't respond. They didn't even do a proper investigation. So what does this mean for this person? Well, because of this situation, he now can treat his employment as being terminated. We call this a constructive dismissal. We've spoken about it before on the show. And a constructive dismissal happens when the employer doesn't fix a poison work environment and you have to go to work and endure harassment. You can say, no, I am not going to take that. I am going to leave and get my severance, and I'm not going to have to suffer because I gave you an opportunity to fix the problem, company. You didn't do it. Now that's the consequence.
And it's full severance, full pop.
Absolute full pop, as if the company let the person go based on age, position, length of employment. And if you're then suffering from workplace harassment, do the right thing. Try to get the problem resolved internally. And if you can't, or if the company won't do anything about it, call me.
Again, 1-855-821-5900 is that number, and severancepaycalculator.com. You want to go to employmenthourtv.ca to find out exactly where we host the Employment Hour, our radio show. All week we do that, take a ton of phone calls on the show. We like to play a few back on the show so you can hear them, get an opinion on them by Lior. Some interesting stuff here, so we got one for you.
My sister-in-law, she works for a fairly large bank. She's been there for 18 years. They emailed her to say she was invited to a meeting, and it was to let her go. And there were 4 others that were let go, and they didn't offer them positions anywhere else. And she's an excellent employee, and I'm not saying that because she's my sister-in-law, but she was in shock, absolute shock.
And John, this is a very common question that I get, a very common example of the types of calls that people make when they reach out to me, because they're upset that they lost their job.
Shocked.
They're shocked. You've worked for a long time. You feel you've done a good job. You've got good performance reviews. All of a sudden, the rug is being pulled out from under you. You're called into a meeting and are let go. How can that be right? Well, it's not right on many levels. Ethically, morally, even from a business standpoint. But from a legal standpoint, the company is allowed to let you go, even if they're not being particularly good about it. They can let you go as long as severance is paid. So the question here with this particular call that we got is not so much, are they doing the right thing, the bank that let the person go, because they're allowed to do it, is are they paying proper severance? So the question is, what is severance? So it's based on age, position, and length of employment. And I created the severance calculator, we'll talk more later, that allows anyone to find out how much that person is owed. Let's plug that into the severance calculator. So a supervisor at a bank, 18 years of service, someone in that situation would get 18 to 24 months of severance. 18 to 24 months. A lot of people are watching right now saying, wait a second, I thought it was a week per year.
Yeah.
Nonsense, it's not. That's why the severance calculator is so important. So if this person did not get 18 to 24 months pay, they were wrongfully dismissed. Not because the reason they were let go is not a good reason, because they didn't get proper severance. So remember, if you lost your job, whether you agree or disagree with the reason, unfortunately, nothing can be done about that. But what we can do is make sure you get proper severance, because guess what? Most people do not get offered proper severance. It's something that we need to work towards getting.
And I know a lot of your job initially when talking to people is getting them over that emotional hump of, I can't believe I lost my job. And your job, I know you say, is to say, okay, we know that part, that's water under the bridge, we can't get your job back, but let's look forward to what you should be getting for compensation.
It is, and sometimes it's very difficult for people to accept.
Sure.
People usually call me because they want their job back. They want to make it as if it never happened.
Yeah.
Unfortunately, there's very few, if any, legal mechanisms available to get the person the job back. The law really doesn't know how to make the company take you back. The law just makes sure that you get proper severance. So oftentimes when someone calls me, I focus them on the severance, not because that's what I want to talk about. It's because that's the only thing that the law knows how to address.
Right. 1-855-821-5900 is the number, help@employmenthour.com. Or in this case, we'll go to help@employmentlawyer.ca for a proper email. Severancepaycalculator.com as well. If you haven't used that, we just ran an example of that. When we come back after a short break, which we're not taking yet, we got lots more to get through. We'll get to an example of the severance pay calculator. That last example there was something an employer could do legally. But I want to talk about a few things how your employer is not allowed to do. And one of them is change your pay, your job description, hours of work, how far you got to travel, stuff like that. Talk about it.
So yeah, we'll talk about a few things that a company is not allowed to do. So if you're sitting there wondering, is my employer allowed to do this? We'll talk about a few things that the employer is absolutely not allowed to do. And a big one is your employer cannot change the terms of your employment in a significant way. So if you are working in a particular job at a particular location with a certain compensation, those are the terms of your employment. Your employer cannot decide unilaterally, well, we're going to demote you or reduce your pay or relocate you or change your compensation structure. They cannot do that. What does that mean, though? That doesn't necessarily mean that there's a way to stop the company. It means that it gives the employee the option of treating that as a constructive dismissal. So if you're faced a significant change in the terms of employment, you may have the option to say, no, I am not accepting as employer. But if the employer does it anyway, you can treat that as a termination, leave and get your full severance. So can your employer change the terms of your employment? Absolutely not.
You know, it makes me think about that story that was in the news just last week and about Tim Hortons moving their operations from Oakville, which is about 40K out of Toronto, to Toronto. I mean, that's a lot of people going to be affected by that. Can they do that? It's a 40-kilometer drive. Yeah.
So for some people, that move from Oakville to Toronto could be a huge move. Depending on where you live, it can increase your commute from 10 minutes to an hour and a half.
Right.
So for some people, that could be a big deal. For others, it may not be a big deal. For some people, this may actually mean that they work closer to home. But for those people that are impacted significantly, that move could be a huge deal, and it could be a constructive dismissal. So an employer does not have a right to relocate employment to the point that now your workday is different. Now you're going to take 3 times longer to commute. If that happens, you can say no, treat that as a constructive dismissal and get severance, even though you're the one leaving. In the eyes of the law, it's still a termination.
So it's not a matter of distance, it's a matter of inconvenience to you.
impact on the person.
Right.
There's no such rule as 2 kilometers is okay, 40 is not. It's not about kilometers. It's about how does this impact you. Sometimes the relocation is going to have a huge impact, sometimes not. If it has a significant impact, it's a constructive dismissal.
Help at employmentlawyer.ca is the email, and 1-855-821-5900 is the number. Talking about things your employment is not allowed to do. Your employer cannot put you on a probation after you've already passed a probation period.
Yeah.
It seems silly, but
A lot of employers do that, and they think that somehow they can, if they're not happy with an employee, they put them on probation. It's meaningless, okay? You can't be put on probation because once you've passed probation, you have certain termination entitlements, and those can't be taken away from you by saying that you're on probation. So for a company to do that, it's silly, it's meaningless. They can put you on a performance improvement plan if it's justified. They can talk to you about your performance in a performance review, but no, they can't really put you on a probation period retroactively once you've already started working. It's silly, it doesn't work, it makes no sense, and if that's what happens to you, frankly, it's meaningless.
speaking of probation, though, is probation periods, no matter what the job, A, are they automatic, and B, is there a length of time they can do it with, and, you know?
So probationary periods are not automatic. They're not assumed. Probationary periods have to be created by an employment agreement, by a written document that you as the employee sign with the employer. So if you started a job, there's no such thing as automatic probation if you haven't agreed to it. So probationary period can usually be up to 3 months, 90 days, and it can only be existing if the employee signs something that says that. And some people believe, a lot of people believe, that you don't get severance if you're on probation. Guess what? Many times, very often, even while on probation, if you lose your job, you still get severance. In fact, it could be significant severance.
We're talking about the things that your employer is not allowed to do to you. Another one is refuse to pay you overtime if you actually work the overtime hours.
Yeah, and we talked about this recently on one of our radio shows. Yep. And the idea is this: if the company doesn't approve the overtime, it does not mean they don't have to pay overtime. If you worked the extra hours because it was necessary to work and you actually did the work, you weren't just sitting in the office twiddling your thumbs, the company has to pay the overtime. It's as simple as that. That's true even if the company says you have to get overtime approved and you don't get it approved, but you actually worked it, they have to pay it. Now, if you worked overtime you weren't supposed to, the company may decide to discipline you, maybe they'll give you a warning, but they still have to pay the overtime. And remember, overtime in Ontario is calculated on the basis of time and a half over 44 hours a week. If you work over 44 hours a week, you get time and a half. And by the way, that applies to salaried employees, not just hourly employees.
1-855-821-5900 is the number to get a hold of Lior anytime. Talking about the things your employer is not allowed to do to you. Make up a bogus negative performance review?
No. A performance review is a big deal, and an employer is expected to be honest, to be reasonable, and be forthright. So if the company is making up allegations that they're not accurate, that's improper, and you should say so. And make sure that the record is correct. You don't want to be silent in the face of a negative and inappropriate performance review. And in some situations, John, if the company clearly is making up allegations in a performance review, that in itself could be a constructive dismissal, because there's an implied term that you're going to be treated fairly and reasonably and professionally. If you're not treated that way, if the company is accusing you of things, putting you down, it's not justified, that's illegal. That's a constructive dismissal.
Now you say so, but you mean say so, but in writing.
Exactly. Right so. Maybe we should say it.
Yeah.
If you disagree with a performance improvement plan or a negative performance review, say so in writing, put that in writing, make sure your position is known. You don't want to be considered to have accepted something that you don't agree with. Things
your employer is not allowed to do to you, take away your seniority by making you an independent contractor.
I've seen this many times, John, where the company says, we want to transfer you, make you an independent contractor, and then you start from scratch. It doesn't work that way. If you're an employee, you can't be made something other than an employee, really, unless the job changes. So, and a lot of companies may think, well, wait a second, that saves us money and maybe saves us future severance by changing someone from an employee to an independent contractor. Can do that. And frankly, even if the company did that, in the eyes of the law, you would still be an employee. So no, there's no legitimacy to a company taking you from the employment status into an independent contractor status. It doesn't work that way.
Final point on this one about the things your employer is not allowed to do to you. And with this one, again, you get a million phone calls on this, and that is lay you off temporarily.
A lot of confusions when it comes to temporary layoffs. So many employers and employees believe that you can be laid off temporarily. The idea being that we're not letting you go. We're essentially suspending employment for a period of time, but then we're going to call you back. No, a temporary layoff in most situations is a termination, except for businesses that are seasonal, etc. Otherwise, if you've been laid off temporarily, if this is the first time, it's not something you expected, you could treat that as a termination and get your severance right now. A company does not have a right to lay you off temporarily.
We're going to talk about the introduction of the 12-hour shift as well as the Severance Pay Calculator. By the way, severancepaycalculator.com after a short break. The number 1-855-821-5900, and it is help@employmentlawyer.ca as well. Sorry. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Severancepaycalculator.com. We will never stop talking about this tool because 500,000 people have used it. It's absolutely free and it will save you much heartache, and it's going to completely get rid of some confusion when it comes to your severance. Talk about that Severance Pay Calculator.
Severancepaycalculator.com. Our regular viewers know about it, but so many people watch this for the first time. It's such an important tool. Again, severancepaycalculator.com. The name says it all. It calculates and tells you how much severance you're owed. It's extremely simple to use. It takes seconds. You answer only a few questions, none of which, by the way, is what your name is or your company's name. It's anonymous. It's free. There's no strings attached to it. And it's the tool you go to if you lost your job and you want to know the real amount owed to you. Spoiler alert, it's not a week's pay per year service
2
or
weeks
2
per
weeks
year.
pay or any such formula. It's based on your age, position, and length of employment. Now that you know that, now that you have that information, you should never, ever have to accept inadequate severance like 90% of people do. That's why I created it, because thousands of people every single year accepted pennies on the dollar, sometimes less, hundreds of thousands of dollars less than what they're actually owed. That's a terrible situation. So go to severancepaycalculator.com, use it even if you haven't lost your job, even if you're just curious and you're wondering, wait a second, what if I did lose my job? What would I be owed? Severancepaycalculator.com. And if you know someone that lost their job, your friend, your neighbor, etc., tell them to check it out as well. They'll be happy that they did. It can save them a lot of money. It's a way to look at your entitlements now in a way that makes it easy. It's accessible. You don't have to worry about calling me. You don't have to worry about who am I going to get a hold of at midnight on a Saturday. Just go to severancepaycalculator.com.
Again, anonymous and free. You don't need a credit card. Don't need any of that stuff. Just plug your info into it. It takes about 30 seconds. There's an employer mode if you want to find out what it would cost to get rid of an employee under your employee. So you can do that as well. Severancepaycalculator.com. Want to get to an example here and have you comment on it. Seb worked 4 years at an auto body shop. After years of hard work and positive customer reviews, he made a minor mistake with a client's vehicle. His boss fired him for cause right on the spot. Did Seb's boss make the right call? Is he owed anything?
Yeah. So let's start with the idea that a termination for cause, what is that? Termination for cause can only happen if the employee is guilty of such significant misconduct that it's impossible to continue employing them. The fact that Seb may have done something wrong, let's assume that he did. Okay? That does not mean that the company can let him go without severance. Right. Not at all. It's not cause. Now, if there's a long history of misconduct and the company has warned him again and again, well, at some point the company may be able to terminate for cause. But most people, in my experience, and I speak to people like that every day, when they're terminated for cause, it's actually not cause. They're owed severance. It's a wrongful dismissal because whatever it is that they did or whatever it is that they've been accused of doing does not rise to the level of cause. So, if we know that Seb in this situation with a minor incident like that cannot be terminated for cause, Seb is owed severance. So how does Seb find out if it's something that they want to do while they're wearing pajamas at home? Go to severancepaycalculator.com, and I took that information, I plugged it into the severance calculator to show our viewers. So he's an auto repair technician, 4 years of employment. I picked an age, let's say 32. Well, Severance Calculator says he's owed 6 to 8 months of pay. Yeah. 6 to 8 months of pay. So not only can he not be let go for cause, he's owed 6 to 8 months of pay. So that's why that's a common example. That's why it's so important to use the calculator. Because again, if we see here on the screen, someone in Seb's situation would be owed that much. If he didn't know that, he may think, well, maybe if there's no cause I'm owed a couple of weeks' pay, what's the point to pursue that? Or in fact, it could be owed as much as 8 months' pay. It's important. Check out severancepaycalculator.com.
Employment Hour TV is another fine resource if you want to find out information on this show and where we do our weekly radio shows as well. Get a lot of phone calls during those shows. We'll play one back, and Lior, I know you'll want to make some comments on it.
I understand that there is a limitation that changes with severance if the payroll is greater than 2.5 million as opposed to lower than 2.5 million.
Yeah, and this is actually, as you just said, a call that we got once recently on our radio show. And we wanted to bring it up here because this is such a common misconception. People believe, and frankly, the government perpetuates that misconception, that you only get severance or you get different severance if you work for a small company versus a big company. So let's make this very, very clear. Your minimum entitlements may be different if you work for a small company versus a big company. Your minimum termination entitlements may be different. But your full entitlements, what we call your common law entitlements, are exactly the same. Big company, small company, multinational company, or local grocery store. Mm-hmm. Your termination entitlements are going to be the same. They're not based on the company size. They're based on your age, your position, and the length of your employment. So don't assume anything else. Bottom line is you get severance, big company or small company. That's a common misconception. In fact, that misconception was one of the reasons why I created the severance calculator to begin with, because people assume they don't get severance. I work for a small company. Well, what would they pay me? Maybe a week's pay if I'm lucky. Nonsense. And by the way, severance usually is measured in months, not even weeks.
Right.
So call me if you lost your job, big company or small company. Go to severancepaycalculator.com. You don't like me, you don't like the calculator, speak to another employment lawyer. But please, please, please don't accept inadequate severance because you don't know any better or because you fall for one of those common misconceptions.
Help at employmentlawyer.ca and 1-855-821-5900 is the number. We'll talk about the introduction of the 12-hour shift and dealing with severance when it comes to obsolete jobs after a short break right here on the Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30. Anytime you want to contact Lior, 1-855-821-5900. It is help at employmentlawyer.ca as well. We do the weekly radio show. You can go to employmenthourtv.ca to find a station where you can catch the show. It's hour long. It's been around for about 5 years. Do a ton of phone calls, a ton of information like we do in this show on the weekend. We'll get to a phone call. And Lior, I know you'll want to make some comments about it too.
My mom, she's been working for a pretty large company for 15 years. She's been working Monday to Fridays with the optional Saturdays. She's been fine with that. But they told everyone that they're going to have to start working 2 days a week, 12 hours a day, then off 2 days, then again 12, 12, 12, 3 days in a row, then off. She's not going to know whether she's working on the weekends or not. It's taking a real toll on her health. And as a 51-year-old woman, I'm sure you can imagine that this is like too much.
That's brutal.
That is brutal,
Yeah.
and it's unfair, it's unreasonable, but more importantly, it's also illegal. And the reason why it's illegal, it goes back to what I said before, and that is that a company is not allowed to change the terms of your employment. Your schedule is one of the most important terms of employment. So in this situation, she works Monday to Friday. She knows when she works. Those are her hours. She's been doing it for a while. And the company, for its reasons, wants to change shifts. That's fine, but it cannot impose that on employees. So what does this mean? She has options. Option number one is she can accept this and say, fine, I'll be the good soldier. I'll accept this change. I'll work these rotating shifts or what have you, and that's that. Fine. But the other option, which in this case seems like the more reasonable option, is she can say, no, I'm not going to do that. And if you force me, if you force the issue, employer, I'm going to treat that as a constructive dismissal. This is a classic constructive dismissal case. When the shifts change, the hours of work change, the schedule changes, you can treat that as a constructive dismissal and leave with severance. Depending on her age, position, and length of employment, she's going to be owed significant amounts. And I wanted our viewers to understand that even though the company may have legitimate business reasons, even though they're implementing changes across the board, does not change the fact that you could treat that still as a constructive dismissal. They don't have a right to do that. So very important lesson there. Now, what would she be owed? Well, again, she can call me to find out, but let's just input that into the severance calculator so that we can get an idea what she'd be owed. So 15 years, and she's 51. I picked the position that says she's in a sales role. She'll be owed right around 16 months pay. 16 months, 1/6. So that's important. A lot of people would have thought, well, she gets a week per year. She's been there 15 years. Maybe it's 30 weeks. No, it's 16 months. So her choices are as follows. She can accept the change, or she can leave knowing that she'd be owed right around 16 months pay. Obviously, that's a personal decision that she has to make, but that's a real option. That's what we call a constructive dismissal.
SeverancePayCalculator.com is the way you calculate that particular number. I mean, this case is a little brutal. 12-hour shifts off and on. It's crazy. But if she thought, you know what, again, want to be the good soldier, can't she say, maybe I'll try it. I'll see how it works. If I don't like it, I'm bailing on it.
And that's exactly what she may want to do in this situation. I would, if I were her, if I wanted to try it out, I would send a note, an email to the employer saying, I'm concerned about this. I don't know if I can make this happen, but I'll try it. I'm going to try it for the next 2, 3, 4 weeks, whatever it is. And after that period of time, if I can't do it, I'll let you know. If she does that, then she's bought herself some time to try it. If she doesn't do that, if she just starts working, she's going to be considered to have accepted these changes, and then she's stuck in them. So if you're going to face a change to the terms of employment, but you're not necessarily ready to treat that as a constructive dismissal, you want to try it out first, that's okay. You have a small window to do that in most cases, but you have to say so. You have to tell your employer in writing that that's what you're doing, that you're trying it out, you don't know yet how that's going to impact you. And at that point, if you still feel that this is not a workable change for you, you still have the right and the option to treat that as a constructive dismissal.
Because if she doesn't and she accepts it, they can do it again.
Yeah.
Again and again.
So now they change the shifts one way.
Right.
If she accepts it, now she's given them the right to do it again. Once there's precedent set that they can change the shift, they can change the hours of work. Once that has been established, they can do it again. And the second time they do it, she won't have the option to treat that as a constructive dismissal. You only have one opportunity in most cases to treat something as a constructive dismissal.
TerminationQuestions.com. That's a great resource for you to ask questions, again, anonymously. You can go there anytime, TerminationQuestions.com. Got one here, Lior. I'll read it to you. It says, my 3-year contract expired a few months ago. However, my employer kept me on until last week when he fired me. When I asked if I would get 2 weeks severance pay, he said my contract declared that I wouldn't get a penny after being let go. Are those contracts ironclad?
Well, that's a very interesting situation. Yeah. So let's talk about this. A fixed-term contract is a contract for a specific period of time, a year, 2 years, whatever it is. Usually what happens is if you're working on a fixed-term contract and the contract ends, it doesn't get renewed, at the end of the contract you don't get severance because you would have had knowledge and notice from the beginning when your employment is going to be terminated. No problem. But what happens is if the contract expires and you continue working, you're now a regular indefinite employee. So if the contract expired on Friday and Monday you're still working there, that contract is gone, it's garbage. Now you're a regular full-time employee immediately, which means if they let you go the next day, now you get severance. So in this situation, the contract, she says, expired a few months before. She gets severance because she's no longer working under contract, and the entire time, the 3 years that she was on, count towards her severance. She could get as much as 6 months pay.
Wow.
Very important.
How many times, quickly, as before we wrap, how many times can they renew a contract before it's like, okay, you're just an employee?
If they actually renew it formally, usually once we're into the third renewal, it's not a real renewal. At that point, it's expected that it's going to be renewed and you become an indefinite hire employee.
Another great show, lots of information. Moving forward, you need to contact Lior, SeverancePayCalculator.com. Find out exactly what that severance should be, 1-855-821-5900, and help@employmentlawyer.ca through email as well. Hope you like the show. Join us again next week. This is the Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.